Hi students, in the previous video we have covered two subtopics of Unit 2, which is definitions of consideration and legal rules regarding consideration. In this video we will cover other two subtopics of consideration, which is suit by a third party to contract. Fourth is validity of an agreement without consideration. So we all know that, let us say there are two parties to a contract, person A and person B, offerer, offeree, promiser, promisee, and you also call acceptor, right? So these two parties who came together made an offer, provided acceptance, consideration was there, enforceable by law, and a contract was established between these parties, right? So we can call them as first party and second party. So let us say there is a stranger who is coming, and can he go to court of law? Can he go to court of law for justice? The answer is pretty much no. The answer is pretty much no in general cases, but there are few exceptions. So, what are the learnings we have learned from the definition of consideration? So, there can be a stranger to a consideration. The answer is yes. So, when we have discussed the definition of consideration, we discussed when at the desire of the promiser, promisee or any other person. Please keep that in inverted commas, any other person. So, A is selling car to B. B can pay the money to A, or a stranger, someone like C, someone like D, can also make payment to A. So the amount has to be at the desire of the A. Amount has to be at the desire of the promiser. But the amount who is paying can be maybe B or maybe stranger. So can there be a stranger to a consideration? The definition from the act itself says yes. The answer is pretty much yes. So can there be a stranger to a consideration? Yes. How do we know? We need to check the definition. The definition says, at the desire of the promiser, promisee or any other person. Promisee or any other person. The any other person can be a stranger. Can there be a stranger to a consideration? The answer is absolutely yes. But can there be a stranger to a contract? Can there be a stranger to a contract? So contract means you need to have an agreement, you need to have an enforceability. So can a stranger who is not involved in the contract, let us say in the classic example what we are taking A and B, can M, can N, who are strangers to the contract, can go and file a case in the court for justice, for some benefit. Okay. So the answer is no. The answer is no. In general, it is no. So what do we call this as? This we call it as doctrine of privity of contract. Doctrine of privity of contract. This means a stranger cannot sue in the court. A stranger to a contract. Can there be a stranger to a contract? The answer is no. So this we call it as doctrine of privity of contract. But there are few exceptions. There are few exceptions. 7 exceptions in totality. We'll discuss those 7 exceptions. But the general answer is no. Let us see those 7 exceptions. First, we'll see that in tabular format. Then we will see it in detailed format. So let us see these 7 cases. So how do we remember? There are 4 A's, 2 C's, and 1 T. Act. Sued by a third party to a contract. In general, the answer is no, but there are 7 special cases where you say yes. So how do you remember? The acronym ACT. So 4 A's, 2 C's, and 1 T. So the first is agent. First is agent, right? So you can also remember the A's in simpler way. You can see the starting letter A and end. Agent, assignment, acknowledgement, a family settlement. It goes in that manner. So agent. So we'll first discuss about agent. So you may be knowing Shah Rukh Khan, you may be knowing Salman Khan, you may be knowing Hrithik Roshan. Do you think all the agreements they enter, all the purchases they do, all the movies they do you think they are the one who will be reading all the agreements? Do you think all the cars they purchases, all the dresses they purchases, they do themselves? They will go to the shop and they'll buy, or they do have managers, they do have servants. So they do have some managers. So those managers, we can consider them as agents. We can consider them as agents. So these agents, let us say one of the agent, one of the manager, okay, he went to buy a car on behalf of one film star. So the film star here is a principal. The film star here is a principal, and he has a manager who is an agent. This agent went to buy a car. This agent went to buy some doing car services. So this agent is acting on behalf of principal, on behalf of principal. He mentions that he is an agent of film star. He always mentions that he is an agent of film star, right? So this agent, when he wants to enter into an agreement with a party for buying products, for obtaining some services, for buying products and for obtaining services, so there is a contract established between agent and second party, agent and the supplier, agent and supplier. So this agent as well as supplier. So now, can principal can principal go to court of law on this agreement? Yes. The reason being, the agent, while entering into a agreement, entering into a contract, he took principal's name. He was acting on behalf of principal. He was acting on behalf of principal. Hence, principal can go to court of law for claiming money for justice. Hope this is clear. So an agent, when he is entering into a contract with some service provider, some goods supplier, he always mentions that this is for the purpose of principal, right? So now, principal who is stranger to a contract, this contract is entered between agent and supplier, agent and service provider. So principal is not involved in this contract. However, principal can go to court of law for the justice. Thereafter, we'll move to next case, which is assignment. Let us say Ankit. Mr. Ankit, he has his wife, he has his children. So he kept them as nominee. He kept them as nominee in the insurance, which he has taken from insurance company. The agreement is between Ankit and insurance company. So let us say the child of Ankit, wife of Ankit, is not a party to the contract. Wife or child of Ankit is stranger to this contract. However, they are the beneficiaries. So nominee can go to court of law, sue the insurance company and obtain the benefit. This is assignment. This is assignment. Next, we have acknowledgement. So let us talk about agent. So in case of agent, the principal, let us say the film star has one manager, official manager, but there are people who claims themselves as managers. There are unofficial managers. There are unofficial managers. Okay. At times, what happens? There are unofficial managers who acts as like an agent, very peculiar scenarios, right? This agent concept, agency concept, we'll discuss in unit 9 of this chapter in detail, but we'll take an example and we'll understand here first. So this acknowledgement. So there is an official agent, there is unofficial agents. There are people so-called themselves as agents of film stars, managers of film stars. So in that case also, can principal go and file the case? Yes, he can do that. So more or less the agent and acknowledgement is one and the same. Here it is official agents. Here so-called agents, so-called managers, unofficial agents, right? So or even to understand it in a better manner, we'll discuss in unit 9. Thereafter, a family settlement. Fourth condition is a family settlement. In case of a family settlement, so let us say A and B, they made an agreement. They made an agreement that they will take care of their mother once in 6 months, half year with elder son, half year with younger son. They made an agreement that they will pay monthly allowances, they will take care of their mother. But B is not taking care of their mother. So B, mother is not forming part of this contract, party of this contract. She is a stranger, although she is beneficiary of this agreement. She is beneficiary of this family settlement. Hence, she can go to court of law. This is with regard to a family settlement. So we discussed 4 exceptional cases where a third party, a stranger to the contract, can go and file case for justice. In case of agency, in case of agent relationship, a principal who is stranger to a contract can go and sue. In case of assignment, a nominee can go and file case in the court. In case of acknowledgement, again, a principal can go. In case of a family settlement, the beneficiary can go and file case, right? Thereafter, certain marriage contracts. Let us say Mrs. H. Mrs. H was Mrs. H. There is Mrs. H who is a beneficiary. So Mr. H promised to his father-in-law, saying that I'll pay monthly allowance to her. I'll not harass her. I'll take care of her. Everything he promised to H's father-in-law. But at some point in time, he has not paid the allowances. He has not paid the allowances. So can Mrs. H can go to court of law? Yes, she can go to court of law because they already made a contract. The contract is between H and H's father-in-law. Although Mrs. H, who is stranger to a contract, can go to court of law based on the legal agreement, legal contract entered between H and H's father-in-law. Next, we have covenant. Covenant is nothing but condition. Condition using the land, condition pertaining to the land. Let us say there is a seller of land, there is a buyer of land. Seller has 2 portions of land. Let us say 2 acres. 1 acre he is selling it to some party, 1 acre he is keeping it with himself. So out of 2 acres, he sold 1 acre to buyer and 1 acre he kept it with him. Unfortunately, seller died and seller's successor, his son, is taking care of those 2 lands. He's taking care of that one acre of land, right? So seller promises to buyer. Seller made a condition to buyer that he will never construct any industry in that 1 acre of land because buyer wants to continue farming in the other 1 acre of land. So who has promised to whom? The seller, while selling his 1 acre of land to buyer, he promises that the 1 portion of land, the 1 acre of land, which is with himself, he will never construct an industry whereby pollution will be coming and it will destroy the other 1 acre. So the condition is between seller and buyer. Now the successor, can he build an industry in that 1 acre? The answer is no. So the conditions, the successor, although he is a third party to a contractor, stranger to a contractor, he should abide by the conditions of the contract. He should abide by the conditions of the contract. He should follow the conditions of the contract. So he cannot say that I am a stranger to a contract. I was not the party to the contract. Now I will do whatever I wanted to do. He cannot do that because his father made a condition, covenant is nothing but condition to the buyer. Hence it also applies to the successor. Next, the last point is trust. In case of a trust, so there is a trustee, there is a settlor, there is a beneficiary. Let us take an example. There is A, B, C. There are 3 friends who will be called as settlor. The one who established the trust, we call them as settlers. So A, B, C, there are 3 friends come together, they established a trust. And what they have done, they put some money, they made some fixed deposits in order to donate some amount, let us say 10,000 rupees per month for old age homes, for orphanages, right? So A, B, C, who are settlers, the one who established the trust, 3 friends, they made some FD, they made some fixed deposit, they established a trust, an artificial person, an artificial organizations, they established a trust, and the money earned from that fixed deposits monthly, it has to be distributed to whom? To old age homes and to orphanages. Now, the old age homes and orphanages are beneficiaries, but they are strangers to this contract. The contract is between the trustee and the settlers. So settlers has invested money and they gave the objective. So it is between the trustees and settlers. However, the beneficiaries, the orphanages and old age homes who are getting monthly income from these trustees, if they get stopped, they can go to court of law for justice. So these are the 7 cases. It is easy to remember with the acronym ACT, with the mnemonic ACT. You have 4 A's: agent, assignment, acknowledgement, a family settlement. Then you have C, which is certain marriage contracts, covenant using the land. T is the trust. Once you understand this, we'll go it in detailed format. So here, contracts enter into through an agent. So the principal can enforce the contract. Yes, he can enforce the contract, although he is stranger to the contract. Then the assignment. So the benefit under a contract has been assigned. So in case of insurance company, insurance contract, the benefit was assigned to nominee. The benefit was assigned to nominee, and he does not have any personal skill. So the moment father died, the benefit was assigned to his son or his daughter. So the daughter or son can go to court of law for the benefit of the contract. Next, we have acknowledgement or estoppel. So as we have discussed, there are agents who are official, there are agents who are unofficial. There are agents who call themselves as managers for a film star. So this also get binding the moment they mentions themselves as agents to managers. So to film stars, the film star or the principal can go and sue them, can go and sue the court, sue in the court. Okay. Thereafter, we have family settlement. In case of family settlement, as we have discussed, the beneficiary can fight. Even not the beneficiary, let us take one example. Let us say there are 3 children. There are 3 children involved. Let us say the entire property gets distributed between A and B. Now C was not aware of that. Can C, after later point in time, can go to court of law? Yes, she can go to court of law. Certain marriage contracts, we have seen H and H's father-in-law for the sake of Mrs. H. Covenant running with the case of land, we discussed 2 acres of land between seller and buyer. The successor has to abide to the conditions. The covenant, nothing but conditions. Last, we have the trust. The beneficiary has the right to go to court of law for justice. So this is where a third party, a stranger to a contract, can go and sue. In other cases, it is absolutely no. Again, the question comes, can there be an agreement without consideration? Recall the definition of agreement. Promises, set of promises, forming consideration to each other, So an agreement cannot form without consideration. So validity of an agreement without consideration is not at all, it is not at all valid. It is not at all valid. But however, there are certain exceptions. So generally, can agreement be valid without consideration? The answer is no, but there are exceptions. Again, there are 7 exceptions. Let us see one by one. So there is an agency. So we discussed about agent in the previous example. So the same case, agency. Section 185 deals with agency. Unit 9 deals with agency, where we cover it in elaborate manner. But to understand this, so you have an agency can be there without consideration. Bailment. Bailment is another example of agreement where it's valid without consideration. Bailment is example, delivery of goods from one person to another person. Delivery of goods from one person to another person. Let us say you have neighbor, they went to tour, they gave their car to you for 7 days. Just to protect the car, they gave the car to you for 7 days. Now this car was given to you for purpose of protection for 7 days. So once they return, you should able to give that car to them. So there is no consideration involved in this. But this type of contracts, we call it as bailment. There is a separate chapter we'll discuss in detail. So these are the two types where you have a contract, you have a valid contract, you have a valid agreement without consideration. Completed gift. So there are donor, donees, there is a charity which you pay, there is a completed gift. So in these cases, there is no consideration. So you just pay the money, there is no consideration from the other party. You just give the gift, not expecting something. You just give some charity, not expecting something. So in these cases, there is a completed gift, there is charity. In these cases, it's valid, it's a valid contract, but however, there is no consideration involved in these two cases also. So there is an agency, there is a bailment, there is completed gift, there is a charity. Next, 4 cases where the agreement, the contract is valid without consideration. Completed gift and charity is straightforward cases. You give gift, you don't expect anything from that party. You give charity, you don't expect anything from that party. So it is only one-way consideration or one-way supply, one-way consideration, but the other way, there is no consideration. Without consideration also, it is valid. Whereas in case of agency and bailment, we'll discuss in detail when we are discussing their respective units, in their respective units. Let us discuss about other 3 cases. Compensation for past voluntary services. So let us take an example of A and B. A took services from B. A took services from B in the past. So B has provided services to A for free, voluntarily. Voluntarily, B has provided some services to A in the past. In the past. Now, A wants to pay money to B in present or in future. So A wants to pay money to B in the present or in future. A promises to B to pay the money in a week's time. So A made a promise to pay money to B, but B is doing anything in present or in future? No. So from B's point of view, there is no consideration to A. However, the consideration was done in the past. So in the past, they have done voluntary services, and B would have done the services only to A or in the presence of A. And now A promises to B. A promises to B that he is going to pay money to B. So all these conditions satisfies, then even though B is not paying anything in present or in future, it is still a valid agreement, a valid contract. So there are 4 conditions one has to satisfy. The services should have been rendered voluntarily. So in the past, you shouldn't have taken consideration. You shouldn't have done it for money or for some consideration. It has to be done freely, voluntarily. And the services was rendered for the promiser, or the promiser must be in existing at the time when services were rendered. And finally, the promiser today or in future, he is telling that he intended to compensate for the promise. All these conditions satisfies, then the agreement or the contract is valid. Thereafter, we have promise to pay time barred debt. So there is a limitation act. Let us say A supplied goods to B. Now A is the creditor for B. A is the creditor for B. B has not made payment to A for 3 years, say about 3 years. The Limitation Act says you will lose the right to collect money after 3 years. After 3 years. So after 3 years, it becomes time barred debt. It becomes time barred debt. So the time has been elapsed for the debt to be collected. So once this time has been passed, time has been elapsed. So can A collect money from B? The answer is generally no. But if B promises to A again that he wants to pay 50% of the money, he wanted to pay 40% of the money, if he promises to A, so in this case, A is not going to supply any material. So for the material which he supplied in the past, he is going to get paid now. The time elapsed debt, the time expired debt, for which if B promises A to make the payment, he can make the payment, right? But from A, there is no consideration to B. Without consideration also, the agreement or the contract is valid. This is promise to pay time barred debt. The last one is natural love and affection. Natural love and affection. There is a near relationship between father, mother, sister, daughter, uncle, aunt, cousin, sister, etc. There are, so you, based on your natural love and affection, you are giving something to them without expecting anything from them. So there is only one-way consideration. There is no two-way considerations, right? So what are the conditions you need to satisfy? There should be a near relationship established. There should be natural love and affection, and it should have been written and registered agreement. It should have been written and registered agreement. So there should be a written and registered agreement. It is not verbal thing. It should be written and registered agreement. This is the important conditions in case of natural love and affection. So it should be a written and registered agreement between two parties who have near relations to each other and enforceable by court of law. Then it is valid without consideration. The agreement and contract is valid without consideration. So these are the 7 cases where the agreement or the contract is valid without consideration. And you can remember the 7 cases, or you can remember at least 5 cases with ABC. A meant for agency, B meant for bailment, C meant for completed gift, charity, compensation for past voluntary services. So 1A, 1B, 3 C's. 1A agency, 1B bailment, 3 C's. C for charity, C for completed gift, C for compensation for past voluntary services. So with this, we are done with Unit 2. We will meet, we will discuss Unit 3 in the next video. Thank you.